first matter to come before the court this morning is State of Ohio versus Schell. It's always a pleasure to see you, counsel. You have 15 minutes to present oral arguments. We've read the briefs, we're ready to proceed when you are.
Thank you. Good morning, Your Honor.
Good morning.
I'm not going to reserve any time for
See, I always wonder, because you can argue against yourself, there's always that.
I'm pushing against the rope here already, so may it please the court. I am Alan Medvick. I represent the appellant in this matter, Schell. Mr. Schell has raised 5 assignments of error, the 5th of these being the validity of the protection order. I would not argue at this time. His full hearing has taken place, and that is currently pending on appeal before this court. Regarding the first 2 issues of sufficiency and manifest weight, I would point to the record. At this point, the state raised 2 issues, or 2 incidents that would, as alleged violations of the protection order against Mr. Schell regarding Mr. Banks. The first being an instance where Mr. Banks was doing work at the end of Mr. Schell's driveway and saw Mr. Schell, I believe the record states, playing with his phone. The second was a later incident where Mr. Schell was driving on a public road where Mr. Banks was working, and as he drove past, although there is some dispute in the evidence as to what kind of car Mr. Banks was driving, or Mr. Schell was driving, and whether that Mr. Banks' testimony was credible in that regard. Regardless of that, at a sufficiency level, the statement of Mr. Banks was that as he drove past, as Mr. Schell drove past, he heard Mr. Banks say something, and he assumed it was directed to him. I don't think the assumption of a witness is going to rise to a level of sufficient evidence to reach evidence beyond a reasonable doubt that Mr. Schell initiated a contact with Mr. Banks. In that regard, there were other people present. No one is sure what was said. I think that the assumption that something being said out of a car window while Mr. Schell was driving past on a public street constitutes a violation of the protection order is highly suspect. I think, and there is no question, it's undisputable that this was a public road and that the protection order issued clearly carved out the ability to be, A, in his own yard, which would speak to the first instance, and secondly, to be on a public road for travel in the second instance. Therefore, I don't see evidence in the record at a sufficiency level where this should not have been a Rule 29 acquittal. Again, as to material weight, I think the evidence regarding the second instance in particular is highly disputable. I think it's inconsistent, and regarding whether they could have reached a guilty verdict based on that is also in question.
Can you ask a question about that?
Sure.
The simple act of him being in his yard, it's his own yard, and the simple act of him driving down the road, he's allowed to drive down the road. It's the taking the cell phone out and taking pictures, and it's the
But
words
again-
coming out the window.
Again, we're at a point of assumption regarding what Mr. Schell was doing with his cell phone in the yard. I think he does have a right to be in his yard. And there is no evidence, especially in that first instance, of Mr. Schell speaking to Mr. Banks, of him, and the question of him being on his cell phone, and even if taking a picture, does that constitute a contact with Mr. Banks in that instance? I think that's an open question, not one that I raised here, but I think there was no interaction, there was no conversation, there was nothing outside Mr. Schell being in his yard at a time when Mr. Banks was at the end of his driveway.
Taking a picture of somebody you would consider interaction.
I would,
I'm assuming
I
you
think
did.
that that's,
We don't even know that he did, I'm just
and
asking.
I'm not sure that I would consider that
Okay.
an on interaction or contact. I think that's, and I'm not trying to stretch this out beyond the facts. I mean, what is the level of contact that has to be initiated? I know that at this point, is a passive camera, a dash cam, the body cam, does that constitute contact if you walk past someone at that point? Does it being on your cell phone? And again, I don't know we even get to that point, because I think that's an assumption as to whether photos were being taken or what was happening while Mr. Schell was on his phone on that day. Which would bring me to the third and fourth assignments of error here. The first being, both being plain error arguments regarding the jury instructions. The first is a question of vagueness as to what the actual offense was. The testimony speaks to two distinct instances of alleged violation. There's only one charge here. There's only one charge of a violation, and so this went back to a jury, and there is no interrogatory, there is no other statement given to try to clear up what this potential single violation was, and therefore you have an ambiguous jury instruction, which probably should have been brought, if they were going to argue both charges, those should have been two separate counts. And in this instance, you cannot tell from the record or from the jury verdicts whether there was unanimity in the verdict to find Mr. Schell in violation of either of these. I mean, it's potential that 8 found him in violation of the day he was in the yard, and 4 found him in violation of the day he was in the car. There's clear inconsistency there, and that at that point, I think you have a verdict that needs to be, I think you have a mistrial in this case, based on that ambiguity in the jury instructions and in the indictment. They say on or about August 27th, but they speak only to one instance. I don't think there's a claim that this was a continuing course of conduct that was not raised. They speak to, in the record, to 2 separate instances. I think that you're looking at, I think you're looking at a verdict that can't be supported by unanimity.
Refresh my recollection, Mr. Mendick, did both of those incidents happen on August 27th or separate days?
No, the allegation is that the car incident happened on a separate date.
Thank you.
That when he was on the road, that was a different date, a later date.
Was that the date the intimidation that was ultimately dismissed was associated with?
The intimidation was actually against a different party, against Mr.
Right,
Johnson.
I'm sorry, thank you.
And that was a not guilty verdict on those charges, but the misdemeanor VPO was found guilty. The state, in their reply, questions whether a transcript of the jury instructions was required for both my assignments of error regarding or assignments of error 3 and 4. I would point to the Dowie case out of this county, out of this district, that only the jury instruction transcript is only required if there is if the error is not present already in the record. The jury instructions have been provided as a part of the record and are required to be so, and are required, and a copy of what was read into the record is required by Criminal Rule 30. I don't think that the jury instructions repeating those in transcript form are necessary for this court to address these issues. Lastly, my 4th assignment of error is regarding the failure of the trial court to submit the validity of the protection order to the jury as an element of the offense. I have provided a case, State versus Blaine, out of another district, which clearly held that the court could not take judicial notice of a CPO and its validity. That it is an element of defense and needs to be considered a part of the jury. As in the Blaine case, the parte CPO was heard by a magistrate, and that magistrate was overseen by a different trial judge than the trial judge who heard the trial here. So there is no continuing proceeding before this court. They could have, before the trial court, they could have allowed for judicial notice. Judicial notice was not taken. Mr. Schell, trial counsel, challenged the validity of the CPO throughout the proceeding, and yet at trial there was no, as part of the jury instruction, there was no requirement that they find a valid CPO to be there as an element of the offense.
But they had to find service of a CPO, correct?
They would have to had to have found service, but yes, but the validity and the actual presence and the determination as to whether that was a valid CPO is, I believe, an element of the offense, and any element of the offense has to go to a jury. I think that's been upheld most recently in that A-line case out of the Supreme Court, 113, Supreme Court 2151.
The state's maintaining that there's stipulation as to service, is that the case?
There was no stipulation to service. There was actually, the service here was challenged.
That's what I got from
And-
your brief, but
No.
any explanation as to why it's the complete opposite assertion and the other side say, maybe don't, I just.
I don't believe that, no, I'm sorry.
The impression I got was the original witness called perhaps wasn't the best witness, and the court was going to continue to get a better witness. And from the state's brief, it appears as though then the defense counsel conceded to that
And
witness.
if that is the
testimony.
case, and I opened the transcript, I obviously apologize.
Well, again, I get that from briefs, not from transcripts, so I
Okay.
don't know if that's exactly what happened.
And at this point, so the rest,
Thank
the
you.
balance of my time.
Thank you.
Thank you.
Thank you.
Court will take the matter under advisement, issue a written decision, which will be known to both sides and posted on the Alaska